Are we on? We are. Welcome to the Listen to This Bull live show. This is the show where we talk about bullshit in the insurance world, and you drive the conversation by asking us questions. We have some big bullshit to talk about today. What do you think, John?
I think I wasn't ready, but I'm excited.
Yeah. Today we are talking about my co-host, Remington Huggins. We're going to get his story, and we're going to ask him a bunch of questions about the plight of property plaintiff attorneys and how it is that they do their jobs. So without further ado. That just said that we're not attorneys, but here comes one. Remington.
What's going on, Matt? What's going on, John?
Going on, buddy?
Nothing much.
You've never been on this show before, Remington, so maybe I should tell you how it works.
Yeah, please do. Enlighten me.
For anyone that hasn't watched a lot or listened to a lot of the Listen to This Bull show, Remington is on often. He's my co-host. He doesn't get on every week because he does attorney-ish things sometimes, which I don't agree with, but whatever. It's fine, I guess. He also takes vacations from time to time. Also, I don't think he should ever do that, but it is what it is. But Remington normally sits there and asks all the important questions while I get lost in some of the details of what somebody is saying and pulls the show together. You're a good guy. My kids call you Big Law.
I'll take it. Tell him I said thank you.
I just made you a background that says Remington Huggins presents Big Law. I'll email it to you. Big Law.
We've done a lot of things together.
I'm glad I'm the guest on the show this time. I don't have to worry about forming these questions to make the glue to make the conversation stick and go forward. I can just sit here all happy and merry and just answer all the questions that you might have.
Yeah, you're being really
funny if I just failed to ask questions and you had to ask yourself questions in order to continue the progression of the show.
Yeah.
Maybe I should do that.
I will. Maybe I will.
Maybe you will. Yanni is saying hi. What's up, Pate? Pate Smith.
Pate, what's going on, buddy?
Dude, I haven't really talked to Pate in so long. It's kind of weird. All right.
He's a busy guy.
So you're an attorney, right?
That is correct.
Have you ever done any other type of work other than property insurance?
No. Now, just to be like really specific, property insurance, 100% of my work that I've done in more than half a decade. When I first started, I did property insurance. But, every once in a while, things came in the door and I would help and assist people with, some different matters. But I can tell you this, in the last 7 years, it's been 100% of my work is property insurance claims.
Do you think that attorneys that do other types of insurance or other types of claims, other types of cases, other than property insurance, do you think that property insurance attorneys that do other types of cases as well are just as good as ones that do solely property insurance?
Yeah, so I've heard that question before. It's a case-by-case situation. I look at it this way. If you're an attorney, let's just say you're an athlete. Just because you're good at football doesn't mean you're good at soccer. And I think that goes both ways. Just because you're a good litigation attorney for property insurance claims doesn't mean that you're going to be a great divorce attorney. Two different ball games, way two different spectrums of the legal field. So I like to say this. If you are a client or a potential client looking to hire an attorney, I don't care what it is. I don't care if it is a closing of a house. I don't care if it's an easement on the property or you're wanting to sue somebody. My suggestion is to get somebody who specializes in that field and only does that type of work. If not, I truly believe you're at a disadvantage. If it's somebody who just is a Swiss Army knife and likes to do a little bit of everything, I'm still telling you they're at a disadvantage, in my opinion, especially in this field, because there's so many, the laws are changing. If you don't read policy every single day, if you don't read Xactimate or review Xactimate estimates and have these conversations with public adjusters and contractors and clients, I'm telling you, man, your head's going to be below water and you're going to be sinking. There's no doubt about it.
So as a rule of thumb, then, if you were looking for a good property attorney as a PA or a contractor, you probably want to look for someone that's doing strictly property cases.
100%. Get somebody, I don't care who it is, but get an attorney who, this is my suggestion. If you are a contractor or you are a public adjuster, you need to have a great relationship with an attorney. You need to have an attorney that you trust. It only makes your life easier, and it makes your clients happier. It truly does. That you have that confidence to say, hey, look, we've been stonewalled. The contractor inspected the roof system, found damage everywhere. Here are the photos. The evidence is there. Me as the public adjuster looked at your policy. We think you are due a full roof replacement by your carrier. However, you're being wrongfully denied or underpaid. This is a guy or a girl that knows what he's doing, or she knows what she's doing. And I've worked hundreds of claims with them throughout the last half decade. And he goes to battle on these types of claims every single hour of the day. You know, you got to have that confidence rather than, hey, here's an attorney. You should have a conversation with them and just see how it goes. Like, a public adjuster should have that confidence. A contractor should have that confidence in the attorney of their choice. I think that's huge. And and picking a good attorney as a public adjuster or contractor only makes you more money as well. Not only makes your client happy, your mutual client, but it makes you more money. You know, a guy who's going to have a better settlement than an attorney that doesn't dabble in this field. The contractor's getting the work after there's a settlement. You know, these are important things that contractors and public adjusters need to think about when they are determining what attorney to give it to, and somebody they trust as well. And I say it by this, like, you giving a file to an attorney, having this mutual client, and know that they are they are being treated how they should, and the case is being handled how it should. And you have that confidence, because if not, you know, every 2 weeks, you're going to be shooting an email over or calling and saying, hey, I have a list of these clients I sent over. I want updates. Rather than doing that, you wait for the mail to come and wait for a check to arrive at your office for your public adjusting fee, or a check from the homeowner to the contractor saying it's time to put on my roof. Can you come over and show me the different type of shingles you have? Like, that's the kind of confidence a contractor and a public adjuster need to have in their attorney. And and again, I'm not speaking for all attorneys, but we, as it is pillars here, that we make sure that these public adjusters are taken care of, that send us files, and these contractors are satisfied with the work being completed. All at the same time, we have the same exact client that we all need to make happy. So, there's a lot that comes into play on being a plaintiff's first party attorney. There's no doubt.
So what you're saying is use the right tool for the job.
There you go.
What a tool. What a tool. The best of tools.
No pun intended, Matt. No pun intended.
So what did you do before you were an attorney, Remington?
Before I was an attorney.
Abercrombie model.
What?
I had someone.
I never went down that route before. I swear.
He had offered. He just never took them.
Yeah, no, didn't take it. That wasn't for me. By the way, all the listeners out there, if you don't know John and Matt that well, they love to have fun and joke with me about stuff. So just giving you some context for the podcast. There's no doubt about it. And I love these guys. They're funny as hell. But before I was an attorney, literally since I was 18 years old, I was in the legal field. You name it, public adjuster's office. Oh my gosh, listen to me. Public defender's office. as an intern, a big corporate in-house intern, to personal injury, if you want to call it paralegal. I've been through all of it since I was 18 years old. And while I was in college, I remodeled bathrooms, kitchens, everything else to get through college. So I did that a bunch. And but I always knew since I was in elementary school that I wanted to be an attorney. No one in my whole family is an attorney. It's just something that I noticed I wanted to do. I can say this: when I went to law school, I did not know I was going to be a roof attorney or a first party property insurance attorney. I truly didn't. But
you didn't go to law school to be a first party plaintiff, first. Is there a term for it?
A first party coverage attorney, first party litigation attorney. There's different little sayings for it.
That's any first party attorney, right? So do you have to say property as a part of it?
I say property because that's really what we do, is all property, unless it's business interruption. But really that stems to property, theft, business interruption, ALE, it all stems from a property loss. So I always throw in property, but in insurance coverage attorney, people use that term as well. There's all these little different nuances that if they're out there. And, I went to law school in Florida. So guess what? I was introduced to first party property insurance work being in Florida. As we all know, that's the state. I would say Florida and Texas really are the they carry the torch, so to speak, for all the other states in a sense. You could say definitely Florida. Okay. A lot of things come out of Florida, but it's more prevalent there. I mean, all the hurricanes, you name it. In Georgia, you tell somebody you're a property insurance coverage attorney, they're like, oh, so you do real estate closings. It's like, no, I do not do real estate closings. But so that's where it came from, and also having that construction background for a long time of remodeling bathrooms and kitchens and you name it. It was something that I was introduced to in Florida. And I, ever since, I just knew, this is something that I'm very interested in and I want to pursue. And I literally had this conversation like 2 weeks ago where I told one of my family members, I was like, this is what I'm going to do the rest of my life. There's no doubt about it. Like this, I am 100% committed to being a coverage attorney for the rest of my career. I really am. I love it. I truly do.
Do the defense attorneys call themselves denial attorneys?
You know what? I'm going to say that to one of my defense counsel friends. I'm going to say, oh, we got the denial attorney on the phone. See,
second party property loophole attorney.
There is. I swear, it's funny you say that, Matt, because let's just say one of John, your clients, or one of your clients, Matt, they're asked to perform an examination under oath, also known as an EUO.
Mm-hmm.
If you do that, if one of your clients has one of those requests, 100%, I've always said it, Matt, you'll know it. John, you heard me speak at the hurricane class, but you must get an attorney. I don't care what attorney, you get an attorney to get involved on that. Okay. But I say this by saying that is this: whoever requests the EUO, I can tell you if it's going to be denied or not. I can tell you before we step in that room if that claim's being denied, just by the defense counsel that's taking the examination under oath. Now, that speaks some volumes. So there are denial attorneys out there, and I'm going to forever reference these individuals. I'll never say them by name. These individuals, we say them within the law firm because we all know, but I will be referencing them as denial attorneys. In fact, I'm going to make a list of these individuals so everybody that's an associate knows to get prepared for it.
Well, along the same lines, we know whether it's going to get denied or not just by who the carrier is also. So, when they say we have such and such, like, that's be a good one.
You could do the same thing based on which engineer gets assigned.
Yeah.
Engineer, probably a desk adjuster. Let's just be honest. Yeah. It comes in different, but it's, to me, that's unfair to these policyholders that are paying premiums. That if you think about it, it's okay. Not only are they paying these premiums, but they're going to be actually subject to a denial because of the engineer that was hired, because of the desk adjuster that was assigned to the claim, or the legal counsel that is now preparing for this EUO. It's pretty, that's not how this system should be, but it is, in a lot of sense. I mean, it truly is.
I have a recorded phone call with an adjuster on my phone where the adjuster was basically admitting that the approval or denial for within that carrier is based on which team it gets assigned to. Because I had 2 claims with that same carrier, and it was almost like it was identical material, almost identical damage, but 2 totally different outcomes. And I brought it up to the guy, and I was like, he said his answer was, well, that team, gives more away, and my team manager won't let me. So, and I was like, so it's really how they get indemnified is based upon which team they happen to get assigned to. And he's like, pretty much. So,
it's unfair.
Yeah.
No, it's a crazy thing. Remington, you've been doing this for how long now? You said over half a decade, but I think it's been a little longer than that, hasn't it?
Oh, yeah. No, it has. It's been, it's been about 8 years where this is all I've done for about 8 years. I've handled, I mean, we were counting, it's over 3,000 to 4,000 clients that I've represented, with their claims or lawsuits in the last 8 years. So it's
first
been
time I met you. I was actually told about Remington before you were barred from I was a roofer at the time, and one of my sales guys knew of you through a family friend or something along those lines, and knew that you were about to get barred and you were going into property insurance or coverage insurance or whatever. And I was very interested. So the first time that you came over to the office, your employer was there with you and sat down, and you didn't say very much. You still had a rattle in your hand. There was a pacifier around your neck on a chain. You were very, very young in this industry. A very, very real way, our companies grew up together, and we got to see, how it is that we work. We've learned a lot over the years from each other. It's really exciting to see how things have progressed. But I got to know, when you were a young attorney in this industry, what kind of issues did you come across that you had a hard time with?
Yeah. Well, first off, let me say this. When I walked, so this was, I think, back in either 2012 or 2013. I don't know, give or take it during that time. But Matt and I did connect, and I went over to his office. And I remember I walked into his office, and the first thing I saw, and I'll always tell the story, was a huge dartboard. And on the dartboard, it had different insurance carrier names on it, where during lunch, they would throw darts at the carrier names. When I walked in, I was like, you know what? I'm going to like this guy. I think me and him are going to hit it off pretty well. But that was my first, before I even met Matt, I saw that and I was like, okay, I'm going to like him. But,
How about that?
A lot of attorneys, what's the old saying? Fake it till you make it. Like when you're in a conversation as a young attorney in this field, and you have a contractor and they're saying these terms, and they're talking about repairability and how you can't repair this particular shingle. It's got to be full roof replacement. And you have a public adjuster that you're talking to, and he's throwing out terms like ACV, RCV, depreciation, O&L, ALE, inflation guard. Like you as an attorney, you can only take in so much information and really process it. It's like drinking water out of a fire hydrant. It truly is when you first step into this. And you just kind of nod your head and go along with it. And you write down notes, and then you get home and then you look and you Google these terms.
Google the hell out of it.
What is going on? I am just being honest. That is 100% what every attorney does. Not in just this.
You have to be an expert. You have to be an expert right away.
You're supposed to be.
Or at least be perceived as one in order to get work. If you weren't, would you get any work?
I mean, think about it. If a public adjuster met with an attorney and he didn't know what RCV meant, there's no way you would send that guy a file, right?
No.
So
if you didn't learn that in law school?
What's that?
You didn't learn that in law school?
You don't. No. If you right now go ask all the law school students who are about to graduate this next semester, and you ask them what RCV and ACV mean, I'm telling you right now, there's probably 1% that know what that is. I'm just being honest, because this stuff is not taught in law school. It's not.
They don't have property insurance coverage classes?
No, they don't.
Then what do you do? Same thing the rest of us do in college, drink?
Yeah, the closest thing you get to that in law school is contracts, right? And the policies of contracts. So that's the way you kind of get your grip on the situation and first party, and then you go from there. And now I'm not afraid to ask Matt or John questions, and no attorney should. I don't have a pride to say, hey, John, why is this not repairable? Please show me why, or Matt, where in the policy are you seeing that this should not be a denied claim? Because I'm not seeing it. Like, I now don't care about those situations. I want to learn as much as I can still to this day. But at first, I'm telling you, any new attorney in this field, if you go and talk to them, they're going to sit there and go, and it's just, there is no doubt about it. And I mean, NCI even has a class on this, like teaching attorneys how to do public adjusting, right?
Right.
I mean, really, it's something that I think is very important for any attorney. I wish I had it. When I knew I was getting in this field, I would have loved to have something like that. But I played the live and learn game, and it's worked out. But yeah, no, there's nothing easy about it.
Outside of that one class that NCI happens to have, is there any place or a source where a new property coverage attorney can gain information like that without the public knowing that you're going to that class?
Yeah, it's without going to that class, the only other resource would be to have some type of mentor, to join up with a law firm that does this day in and day out and learn from that law firm, or learn from somebody who's been doing this for many years. And then you pick up your way of actually practicing law in first party. But other than that, I mean, you can also pick up books and read some books, but there's not many out there. This is a small field in the attorney world. It truly is. Yeah. So there's not a ton of resources out there.
And there's got to be a bunch of like pride barriers too for, even new guys coming in that think, oh shit, should I know what that is? Am I looking stupid? And who's going to go out there and throw out a podcast for attorneys to teach basics? Because I would have assumed that would have been day one, but apparently it was cake stands.
Man, they throw you through the ringer in law school, where law school is nothing like practicing in real life. It's truly not. They want to make sure you want it, and they're going to bust your butt. You're going to have to bust your butt to want it, to get through school, pass the bar, because practicing is nothing like law school. It's truly not. Any attorney that says it is, I don't know. I'd like to have a discussion with them, because I don't agree.
It's probably quite similar to getting a PA license. You take this possibly a 40-hour course if your state requires it, pass an exam if your state requires it, send in an application fee, and you get a bond. Yeah. And you've learned some terms and about some parts of insurance you're not even allowed to practice in, and you just throw that information out the window because none of it is going to help you with the claim.
Right.
Yeah. Trade school the same way. On trade school, I mean, you get 90% in the first 90 days OJT. You get the christening to go out there and hurt yourself. You got to learn the rest, the hard way.
Yeah.
Yep.
How long does law school take?
Yeah. So you have to have your undergraduate degree. So just typical average is 4 years. Then you have to prepare for the LSAT, usually a 6-month process, give or take. You take the LSAT, you apply to law schools, and then law school typically takes 3 years. I did it in 2.5. I did some summer classes. I was ready to go. So law school is a 3-year deal. And then as soon as you graduate law school, you got to start studying for the bar. It's, 12 to 15-hour days of just reading, studying all day for 4 to 6 months. And then you take the bar exam, and then you have to wait another, it matters what state you're in, but 2 to 3 months for the results. So all in all, you got 4 years undergrad, 3 years, and then to actually get your license and so forth. I would say it's an 8-year process, to get it on average.
How long do you think it took you before you felt like you had a grasp of property insurance?
About a decade.
I'm not there yet, guys. Still figuring out collars.
I was, still figuring out collars. I was, it's the way I like to do things. And any new attorney at even our law firm, this is how we do it. We push them in. We push them in, and they're knee deep from day one. And that's how I was. I had to figure a lot of this out. I would say, man, within those first 2 months, I learned so much. I really did. I think it really takes somebody 12 months of all day, every day in this field to really feel confident going to any room, to have any conversation with any entity or any person that's in this field. I don't care if it's an engineer, a contractor, a public adjuster, or a client that has a portfolio of 100 hotels. Like, it really takes that long to go in there confidently and have that conversation and sit down and let them know that you know what the hell you're talking about. Because I know you guys know this as well. You're in a phone conversation or sitting in a meeting with somebody, whether it's a public adjuster, contractor, or an attorney, and within the first 5 minutes, if they're full of it or not. If they don't know what they're talking about, like you truly do. Now that we all know this field so well, like you're just like, that doesn't add up, But I would say it takes a good 12 months of really being able to have a conversation with anybody across the board in this field and be confident about it.
Did you feel like you could take on the world and get bad faith on every case when you were brand new?
It's one of those. Yes. Yeah. It's all right. You enter this field and you hear of all these glory stories, right? All these battle stories about getting bad faith and, Googling bad faith and insurance, and across the nation, there's cases that pop up about it. So you do think you can get bad faith in a ton of cases. The reality is that's false. How about this? It matters what state you're in. Okay. I'm an attorney in Florida as well as Georgia, 2 different worlds. And I know anybody in this industry knows that as well, but it really is 2 different, it's 2 different countries almost. So the conversations I have with clients, potential clients, before signing them up is make sure their expectations are in line with, how this is about to go. And I tailor those expectations to what state I'm in, to who's the carrier, and who I know is going to be opposing counsel. But
same way that we do for any adjuster meeting that's about to happen, who the insurance company is, who the adjuster that's assigned, and the facts of the claim, obviously. It would tailor how I would approach a claim.
100%. And please, public adjusters and contractors, I ask you one favor, and that is, please do not oversell client expectations when you're about to send them to an attorney. Let the attorney provide those expectations. Truly. Because if you're just saying, hey, look, all these attorneys' fees are going to be paid for, this public adjuster that I got involved out the gate, his fees are going to be paid for, and I'll be able to do the work. All you're going to have to do is pay your deductible. I promise. Go to this guy. Sometimes it doesn't work out that way. And guess who's mad? The client. And guess who gets to hear an earful of it? We do, so I would ask, just temper the expectations. I would have a conversation with the attorney that you like and you sending files to, and have that real conversation with them on how, when they ask about how this is going to go, this client, before you talk to them, how would you like for me to describe what to expect? I think that's huge. It truly is. And any attorney out there in this first party world will tell you the same exact thing. There's no doubt.
But that's the same matter.
Contractors that send PAs work. Now they will overvalue what the PA is able to do and say, I guarantee they'll be able to do something. You can't guarantee shit.
Or themselves. Oh, I'll get this bought, no problem. I got you. Do it.
No, it's a terrible thing. So if you were a new PA or a new attorney again, is there something that you wish you had known early on that you know now?
No, just because of going through the learning curve has really made me who I am now, and what, me and my team, Michael Turner and Foster and others have done. I just think you got to have growing pains sometimes. You do. So I am fine with it. What's happened? What's that, John?
You got to touch the stove.
You got to touch the stove. You do. And I just because I've been in the legal field since I was 18 years old, like I know how things should go in my mind. I know how things should go and how things shouldn't go. And I know how to treat clients and how not to treat clients. Like I've seen it since I was 18. And, I've seen what my bosses have done and say, I am not doing that. Or, that's a great idea. I'm going to hold on to that, And so I've kind of lived it before I jumped in when it comes to clients and so forth. But it's a live and learn situation. It truly is.
It's also very dynamic. The whole industry is dynamic. So even what you may have learned 10 years ago just does not apply these days. You know what I mean?
Right.
Building practices change with code and whatever else, new materials coming out, to new policies being written for, public adjusters to argue and right up the line to you guys too. So yeah, it doesn't even matter. It's whoever, like you said before, unless you're reading them every day, you're in them every day, and you're staying up to date on what's happening, you're gonna be lost in the weeds regardless. So
I have an excellent question for you. I'm really proud of myself for how good this question that's about to come out of my mouth is.
Everybody close your ears.
Right. It's probably not as good as I think it is. But whenever attorneys speak at public adjuster or even contractor events in this industry, they often talk about all the different case law and stuff. And a lot of the contractors and PAs, they think they get excited about it. But how important is it, do you think, public adjusters and contractors need to pay attention to case law that's coming out in the state?
Yeah. Great question, Matt. Okay.
See,
there are some instances. So presently, when I do speaking events, I don't throw up a ton of case law. I just don't. Now I will when it's necessary. But there's attorneys, when you see them do a presentation, it's literally every slide there's case law. And I get frustrated from that, even when I'm sitting in the audience, because a public adjuster or a contractor can't use that necessarily as a tool in their everyday course of business. They can't say, hey, Lamb v. Allstate, you're wrong because of XYZ. That's when you're practicing law. When it does matter, though, is, for instance, if there's case law that says for this particular state, let's just use Florida. If the case law says in every single claim, the policyholder must file a sworn proof of loss within 90 days, no matter what, that is very valuable to a public adjuster, right?
Yeah.
Oh, I have to do this. This is law. It's like looking at this, the speed limit. Okay, it's 50. I'm not supposed to go over it. Like I can do this. I can use this in my everyday course of business. It's the stuff where it's like, oh, motion, here's really technicalities for motion for summary judgment, or elements of real bad faith, and really getting in the nitty gritty when they found bad faith in discovery during litigation, things that's not going to help necessarily a public adjuster. So I believe there is case law that would help a contractor and a public adjuster. And there's a lot of case law out there that I guess it shouldn't be taught in a sense, because you're not going to use it, And here's another one, like every state kind of has their own late reporting of a claim. That's very important in my eyes for a contractor.
Notice type stuff. Yeah.
See, that's like very important stuff for a contractor, a public adjuster, that they should know that. Like in Georgia, if there's a hail event and it's 12 months past the date of loss, that contractor should know they cannot use that date of loss, that it's outside of the notice. Just things like that, that are very important for the everyday business of a contractor or a public adjuster. Those are the important things to be taught. I don't like to just talk just to talk. I like to show things that matter to my audience and what they can actually use, rather than sit up there and being like, oh, I'm an attorney, I got my bar license, and let me tell you about this case law. And it's like, first off, they're falling asleep, and second off, they can't even use it. It's not beneficial. So I'm very cautious on the things I use.
TJ McCormick just posted, "Who dis new phone on Facebook? I don't think you know how to use that thing just yet." That's weird.
But
that doesn't make sense.
I think we touched on this a little bit during the hurricane class and some of our little side note chats we had. But case law, it takes 3 or some years for it to actually even appear, doesn't it? Like by the time they get, from when it's filed or the claim is filed till, you go through that process to the litigation, to the judgment reached, and then a case law hits. And couldn't it almost be obsolete? During that time, policies changing, you got new policies hitting the streets and people are in new stuff, and that almost might not even apply by the time. And that case law could be 5 years old. And then by the time you try to apply that case law, it's from an event that happened 10 years ago.
Yeah. It doesn't matter. For instance, like John, being in your shoes as a contractor, there's a lot of times I know when you're like, this guy just doesn't understand because he's not a contractor. And same with Matt, where you're like, this person, whether it's a he or she, just doesn't understand because they're not a public adjuster. This is one of those instances where you kind of only understand it unless you really sit down with an attorney and ask them. But these are one of the situations where I'm like, you need to be an attorney to really understand or ask an attorney about this whole case law situation, because you hit it on the head, John. Let's just go with Hurricane Irma. Okay. 2017, what was it? September 10th, 2017, September 9th, give or take. 2017.
Can't use that data loss anyway.
Yeah, there you go. So let's just go 2.5 years after the loss, they finally file a claim. Now we're 2.5 years out. Then it takes a year for the contractor and public adjuster to work on the claim. And then finally, they're going to knock it over to an attorney. So let's just say that takes 12 months. So now we're 3.5 years out. Okay. Now the attorney gets it. Now he sends a demand, a letter of representation and a demand. It might take them, let's just say 4 months for the insurance carrier to tell them that they're not budging. He has to draft the complaint and file it. So right now we are literally 3.5 years out from the date of loss. Then for case law, the judge would have to rule on something in particular, whether it's a motion for summary judgment, a motion to dismiss, or the actual jury comes with some type of verdict. And then there's an appeal. But that time takes another 2 years. So now we're 5.5 years out. Then you have to, request an appeal. Then you have to get in line for the appellate court, whichever state you're in, to actually review what you're appealing and get to it. It literally can take 5 to 7 years for any type of case from beginning to end to actually get to an appellate court and heard. So what do you need? You need the perfect set of facts, that you are trying to overcome as case law and prove a point with the appellate court. Number two, even more importantly, you need the right clients that are ready to buckle in and sit for that long without seeing any insurance proceeds and wait 5, 6, 7 years. So there's a lot of different variables that come into play. Not to mention, if the carrier has wind that there's going to be good case law in the plaintiff's favor, in the homeowner's favor, they're going to try and settle the case, and they're going to throw money at the client, and then boom, it's gone. So, and they're going to settle. And guys, I can't blame the client for doing that. Like, this is their number one investment, is their home. They're getting a brand new roof. All their interior are taken care of. And they're probably throwing a little bit of money for attorney's fees. Like, you can't blame them for accepting a settlement and not, taking this long trip down Appellate Avenue and hoping with your fingers crossed that there's going to be a change, because there's still at the end of it of 5 to 7 years, you don't know if there's going to be a change. So there's just like all these variables that come into play. That's really, I guess, the only thing where I'm like, somebody say, go make case law. It's like, all right, well, I'm going to have less hair. I'm going to have gray hair, and maybe we're going to make a change, but I'm all about it. I mean, we've tried many times, but the carrier throws money at situations in which it's going to be a long-term effect, to their.
They have a lot more cases to choose
get
from if they want it in their favor.
See,
Can I get a list of these situations they throw money at?
All of it.
All of them. And Matt hit it on the head. We see case law pop up, and I'm like, oh my God, who's his plaintiff's attorney? Why is he even representing his cousin's next door neighbor on this? And these big law firms, it doesn't matter what state you're in, there's big defense law firms. That's where these guys come from. They know this. And they're gonna be like, oh my God, here. We're gonna cherry pick this case. We're gonna make case law for this, and we're gonna run circles around this guy. And they do. And they should. I would too if I was in their position, So, the good thing about it is the plaintiff's attorney, once they're in trouble and they're trying not to make case law, they can't get their client to throw money at an insurance company to make it go away. So versus an insurance company throwing money at a policyholder to make it go away. So, there's a lot of different elements that come into play, no doubt.
Can you withdraw a suit after you file it?
You can withdraw
away from making money.
What's that?
They'd be walking away from any and all money that they might get on it. So it's not necessarily in the policyholder's best interest, but
right.
If there was going to be case law.
I mean, think about if you're a regular homeowner and you file a lawsuit and your attorney is like, hey, we need to dismiss this because your case might not, but it might set some bad precedent for other policyholders. For them to say, oh, okay, well, dismiss my case. I don't care about all this interior damage in my house, tens of thousands, if not $100,000 worth of interior, because it might affect other policyholders that I've never met before. It's hard for them to do that, and I don't blame them. I don't blame them either.
And Joe Schmo, personal injury attorney that's on this case is probably just like any new property attorney, gung-ho and thinking he's going to get bad faith on this because he did some Google searches and they're definitely breaking the law and he can prove it.
Right.
Would you look at a settlement offer as a sign of weakness? Like, okay, I got him if we just keep putting screws to him? Or do you look at a settlement offer as maybe I don't have the strongest case and we should take this?
I don't look at a settlement offer as, we got them. I look at a settlement offer as, does this make sense? Like, does this make sense for my client? And for people that don't know this, attorneys can only do what their clients tell them to do. No, let's just say the breach, they have $50,000 worth of damages at their house, but the insurance carrier offers $500,000. Just using this as an example, we cannot even accept that amount unless our client, the homeowner or commercial building owner, tells us to accept it. So I look at it as, does it make sense? And then I have that conversation with the client, because I understand that how the game's played. These insurance carriers like to get things settled and off their desk, off the litigation adjuster's desk, off of the defense counsel's desk. So throwing money at a case to me doesn't mean it's just weakness, because it's not. And if you're in this game so long, you understand that there's like, all right, let's get this one over with. It's a battle of the experts. They got an engineer. We got an engineer. I don't want to go to, any of these big carriers don't want to go to trial. They don't want to, because trial is public in front of all these jurors, knowing that their own policyholder is suing them for terms under and conditions under the policy. There's other things why they throw money at cases. Yeah. Clients usually need the money. You're exactly right. Pay 100%.
Everybody always needs money. That's capitalism.
Yeah, it is.
There's always something to have. What is the worst case you've ever had?
Wait for you to say something. Like, here, how about this? I'll just give you examples where I meet with a client and, I have this intake form and it just asks simple questions. Have you ever filed a claim on your property? Just things like that. Because we need to know. And nothing surprises me anymore. They say none, right? Take the case, take the roof case. You're going forward, right? There's a deposition scheduled. You sit down with them days in advance and hours of preparation and just talk to them about the deposition, what to expect, what their answers are. Hey, they're going to ask you if you've ever had a claim filed before. Oh, no, never filed a claim. It's like, okay, great. You get in deposition and the defense counsel asks your client, have you ever filed a claim on your property before? They're like, oh, yeah, I've had 4 roof claims in the last 3 years. And by the way, I sold my property and I don't even own it anymore. And you're just like, oh, my God.
Has that happened to you?
Yes. So much. Oh, my God. A lot more than you would ever expect. And so, like,
new house, who this?
who new house, who this, new claims, who, what that? You're just, seriously, you're just like, oh my gosh. And so now, we have a client expectation letter, like, let us know if you sold the property or not, seriously. And let us be honest on if you filed claims or not. I mean, this is huge. Things like that, it just, really gets under my skin.
They do it to us too, but I'm surprised to hear that they would do that to an attorney.
Nothing surprises me anymore, Matt. It truly doesn't. It does not. But, we got to give the client the benefit of the doubt. We have to trust them and roll with it. And then we find out, because when I talk to a client now prior to deposition and things, I tell them, I'm like, look, what do I need to know? What are the red flags that are going to come out? Let's talk about them now so we can try and fix them before it snowballs and we're down the road another 6 months and these things are glaring issues and your case is done. So I really tried to say, like, be open with me. Like, I need to know this, and by the way, everything's confidential. So if you mention anything to me, I can't tell a soul, so that I always kind of lead off with that now, just because, again, it's growing pains. You live and learn, but you would be shocked, Matt and John, about some of the things that
probably not.
Finally, when they're in deposition and defense counsel shows them documents, and I'm like, oh my God, I did not know that you filed 5 claims in the last 3 years. It's just insane.
Yeah, no, I've got them like that where I'm the 4th contractor in line, the 3rd claim, and I had no idea. I thought I'm just doing a standard old job, and oh yeah, I forgot to tell you. It's been denied 7 times. I was hoping you could get it.
I mean, if they don't own the house anymore, they're still owed ACV, right? But if the work was done while they owned it, they might still be owed the money. Outside of that.
Yeah. And let me be specific. And Pate is an attorney. Pate's I consider him a colleague of mine. We actually met, back in like 2010, before either of us got in this industry, but he knows they will sell a property or sell a house, and you won't even find out about it until 6 months later. It's insane. But Matt, to piggyback off your question, it matters what state you're in. I'll be very specific about that. But you're right. If they do sell the property, there's other options such as collecting ACV, such as, it matters what state you're in, but a post sale AOB to the new buyer. And then number 3, if you actually put money into the property, like you replace the roof, you can still go after the RCV of incurred cost. Or number 4, I'm going to say it anyway, even though it's one of my tricks, is, when there is a purchase sale agreement, if you're on notice before the purchase sale agreement, where you reduce the price of the sale because of the damage to the property and have that as a condition, that's something else that you can use.
That reduction in the home's value, but isn't
Correct.
that a diminution?
Diminution in value?
Yeah, which is generally excluded, right?
Generally, yeah. But to me, I argue that it's incurred cost versus diminution in value. Diminution value is more of all right, this house has mold. This one right next to it doesn't have mold. Which one are you going to buy? Right? It's a stigma that follows that property. That's kind of the diminution in value argument. But I hit it as incurred cost. We reduce the price, and this is the reason why. And this is even expressed in the purchase sale agreement.
Because there's still damage that causes that. It's not just diminution of value of the property that you're claiming. It's the damage. And that RCV value was basically paid by the buyer in the form of a reduction.
Yeah, by the buyer, but the seller's pocket's getting hit because they're not selling at the value that they want to.
Right. Because they also have the option of coming out of pocket to fix the damages, to get that, to reclaim it, which would be, more profit on the sell, but they have to forfeit that because they don't have $50,000 to take care of everything.
Correct. So there's different ways to do it, but that it's always an argument.
Lee Waltman is asking, Remington, have you gone up against CoreLogic low ball pricing yet? Do you know what he's talking about?
I do not deal with the pricing of these weather data, databases, so to speak.
I think CoreLogic does more than weather. I'm pretty sure they do appraised values of properties that you would deal with on co-insurance type stuff.
Got it. Yeah. No, have I gone against CoreLogic? I don't. So it's hard for me. How about this? The answer is no, because I've never had a defense counsel or insurance company name CoreLogic as an expert. So I wouldn't go against them or depose them. But, the engineering firms, you know them, Donan, Haig, every single one that you could think of. Yes, I've gone against those, as well as any meteorologist that is named as an expert from the insurance company. I've gone against them, and any consultant that has said it's going to cost X amount to replace this roof or appraise any type of property. I've gone against them, but not CoreLogic specifically, Lee.
How often do they hire a meteorologist?
They don't that much.
No, they don't.
Surprisingly, they don't.
I would actually bet that the ones that you've had meteorologists on, they hired after the suit.
Yeah.
That should tell you something. They don't want that information out.
Right. What they typically do is they run a weather report, whether it's CoreLogic or any of the other databases, and they have that engineer write their report off of that weather report.
I didn't know this, but maybe Lee. So Nolan says Symbility is what they're referring to. Maybe CoreLogic owns Symbility, another pricing service other than Xactimate. Thanks, Nolan.
Yeah.
Well, that should go out the window anyway.
A lot of those. I mean, Symbility is making a comeback right now. It is very different pricing than Xactimate. But I would imagine you're probably not seeing a lot of those cases just yet, because this is something where it's really made its resurgence in the last year or so. It takes a while before it starts getting to the attorneys.
Yeah, it does. I mean, it's one of those things, like, let's just say there's a massive tornado that comes through a particular area. I mean, we wait, it's going to be 6 months before the attorneys see, the first claim. typically.
Yeah. Pate asked an interesting question. What's the funniest thing Matt ever said in a depot?
Excuse me, I got
Matt,
to
I'm
poop.
gonna let you take this one.
Yeah, you were in the room, and Remington can multitask. He's one of the few male individuals that is also extremely attractive and can multitask. It's a very impressive feat. So he's sitting next to me, and he's typing away on his computer, probably answering emails with complex algorithms or something that he's doing in his head while listening to the deposition. And the deposing attorney is asking me the hardball question. And I don't remember what it was, but I know that she was building up to it. And then she hits me with that question. And I didn't answer at that moment. I instead look over to the stenographer.
Court reporter.
The court reporter. They don't have one of those machines that they type on with a few buttons that look like a really tiny kid's piano. They have one of those things that's on their face, and the whole thing is like moving around. And you hear this sound the whole time. I don't know if that came across, but hopefully you heard it.
Something did. Something came across.
And she asks me the hard question. And then I look to the stenographer and I say, "Hey, man, what happens if you sneeze in that thing?" Took all the wind out of her sails. Stenographer literally took it off his face and answered, "I have to clean it out." Sorry, I couldn't go another minute without. I was wondering that the whole time. I honestly don't even know what you just asked me. Could you ask me again? And we continued from there. But
I do remember that, and it was so great because this attorney, he was a well-known attorney in Georgia, defense counsel, was like just blocking this question, just like as a pyramid. And got to the very top, just asked that question to Matt. He looked over and goes, "Hey, court reporter, what do you do if you sneeze in that?" Oh my God.
Did anyone ever check?
That was a good time.
Oh, it was a great time.
Yeah.
I can say this because I know it's 7:02, so I'll leave everybody with this. Is a first party plaintiff's attorney. When I was thinking about it today, when Matt brought this topic up to me, is I feel like we are like the head coach of a football team, and we have all these different individuals. You got the offensive linemen who are the contractors. You got these wide receivers that are the public adjusters. You have the clients who are the quarterbacks. Then on the other side of the field, you have the defense, who is, State Farm, Allstate, Nationwide, Liberty Mutual. You have their head coaches who are their attorneys. And you have to use all these pieces. You have to get the contractor, the public adjuster, and then not to mention engineer, meteorologist, building consultant, and like put all these pieces together and like formulate all these pieces to fit your story and to fit your case and to make the client happy, while at the same time making the public adjuster happy and making the contractor happy. So it's like all these little pieces that you have to formulate, put it together, and to make all these different individuals happy. And by the way, when I say client, I mean clients, because we all know that it's either the wife or the husband. There's either one of them that's sometimes not as happy as the other, and you got to make them both happy. Or if there's an HOA, you got to make 5 of them happy while making the contractor happy, while making the public adjuster happy. So there's all these little different things you put together as the head coach or the general contractor of a claim, if you will, and make it successful. But at the same time, like Matt just brought up what he did in the deposition, you got to have fun with what you're doing. I have a ton of fun. Like, I love the people I work with, whether it's contractors, public adjusters, our clients, the people in the firm. So it just spurred that because you brought up that moment when it was so serious, and these defense counsels for these insurance companies are just they're foaming at the mouth with this question, and you just completely kill them. You just chop them at the knees with a little bit of humor, a little bit of fun. And, that's what it's all about. You got to have fun with what you're doing. You can't take it too serious, or you're not going to have any hair like John. We can't have that happen,
That's head coach stuff right there. That's trying to keep all you guys in mind.
Talk to every attorney that was aspiring to be a first-party property coverage attorney from ever getting into this industry, because it sounds like a lot of work. So
a lot of sync.
Now there's less of them, you'll get more work.
Yeah. I got one quick question. This could be a yes or no, Remy. Do you ever think that this could evolve to fighting more on like the ground level with like the agents that are selling, and how it's interpreted to and sold to the homeowners and things, where could that be kind of like the root cause analysis, as we used to call it, like the problem starts here? Should there be more action on that level versus being reactive later?
Yeah. There's a lot of times, and I know you guys hear it too, John and Matt, any public adjuster, any contractor out there, where the client is saying, well, my agent, when they sold me this policy, they did not tell me about this. They did not tell me about that. You're in great hands, like a good neighbor, everything. So that is, a stemming issue where, honestly, this is not all the time. It's not, but I feel like there's some miscommunication or misrepresentation where an agent is selling a policy to a policyholder, and they're showing them the bottom line, which is the premium, and saying, hey, look, you're getting a deal right here. Look at this premium. However, it's an ACV policy, and they would have a regular policyholder would have no idea what the hell that means. They wouldn't. Seriously, 10 years ago, I would have no idea actual cash value sounds good to me.
It does sound good.
They would have no idea. So that is a problem. On the flip side there, John, like I've seen it where we're in discovery and there's communications between my client and the agent, and that
Uh-oh. Did you freeze on your end too?
I'm here. Yeah, he froze.
Man, but look how good he looks.
I know. Screenshot that.
Right? I need to. Oh, he moved.
There you go. There you go.
And what I was going to say is there's a lot of times where agents go to bat as well for the policyholder. And I see it where there's email correspondence between the agent and the claim side of things. But guess what? At the end of the day, that agent has zero bearing on what that claims department's going to do with a claim.
Right. I just meant
they can have some push. They can have some. They can be somewhat persuasive, possibly. But you're right. So if someone wanted to get a hold of you to help them out with their claim in Florida or Georgia, how should they do that?
What you need to do is go to that lawhuggins.com, shoot an email over to my office, to me, or pick up the phone and give us a phone call. And this goes all out to not just policyholders, but any contractor, any public adjuster that wants to have a conversation. Because look, during the process of insurance work, you're going to be put in situations where you're like, oh man, I want to bounce this off of somebody. I want to bounce this off an attorney. Pick up the phone and call us. I'm literally on the phone with contractors and public adjusters every 15 minutes of the day. I really am. I enjoy it. And that's, obviously zero cost. I just want to have these conversations because I want to, if I can teach somebody something, I will. And if I can learn something, I want to learn it from them as well.
Why is Remington's arm getting so small? Is he talking about that?
It's because of life, Pate. It's because of life. Life happens. You start getting more employees and more claims, and that's less, time working out, man. It's just part of it.
Yeah.
Hey, let's get Pate on this show for a little. Hey, what was our old saying?
Pubs and policies.
Pubs and policies. Let's do a pubs and policies.
Yeah, Pate, if you're down with that, I'll send you a Calendly link. We should schedule that. Honestly, that'd be great.
I want paid on here. Let's do it. Let's make it happen.
Yeah, we haven't done that in a long time. All right, so there's your email address, lawhuggins.com, because apparently hugginslaw.com was taken, I assume.
It's some law firm out in Nevada has that. And
Yeah.
I called and tried to buy it from him, and he wouldn't even, he says it's not for sale. I said, okay.
What a
Well,
schmuck.
Law
Doesn't he
Huggins
know
it
that
is.
he's the least popular Huggins Law?
Well, yeah.
Terrible.
About law
Terrible.
hugs. I'll give you a big law hug.
I appreciate you being our guest today, Remington, instead of being in the co-host seat. Actually, I think it's going to end up being a really good episode. There's a lot of really good stuff in there that I didn't know. I wrote down some notes. All right, so if you guys are liking this show, there's ways that you can help us out. We have a Patreon account, patreon.com /L2TB. And there is ways that you can donate to the show, or if you're looking for some expert help from us or consulting work, there are some subscription models for you to get consultation from us through that. And that will help pay for the show, pay for the lighting, the microphones, all that stuff. An attorney as awesome as Remington, he needs some instruction on how to work his shirt collars. And we got to get that for him. And that's expensive.
It is. It is.
Also, take a look at our sponsors, the National Claims Institute at nationalclaims.institute. We have a lot of stuff going on. We just put up a new course. We've been doing the Dealing with Engineers class on the road at different locations this year, all year. It became our most popular class. Well, we have it online now. On September 19th, you can take an online webinar of Dealing with Engineers. And this is one of those classes that I think is actually really important, regardless whether you're dealing with engineers, especially if you're a PA, maybe even an attorney. We teach you how to identify what is going to be the likely denial up front so that you can do things to avoid that denial altogether while there's an engineer involved, and all the problems that go along with it. It's a fantastic class. I'm biased as hell, but I think it's probably one of the better ones that we put together. And you can buy shirts on our website, listentothisbull.com. I think that's everything. Oh, coming up on September 16th, before the Dealing with Engineers, we also still have the free event for contractors, Roofing Ahead of the Curve, presented by the world's greatest roofer, and EuroShield is going to be at the National Claims Institute, but it's also available online on Facebook and TikTok and Instagram Live and every possible way of going live. YouTube, it will be available for you to watch, but it's a free event. You can come to the National Claims Institute in Florida to see it. We're going to do all kinds of stuff. There is 12 hours of individual instruction about getting ahead of the way things are changing in the roofing industry for contractors. We're even going to shoot a bunch of stuff with a hail cannon, which is what I'm going to enjoy. So make your way to that if you can. There's a lot of stuff that's being given away for free, a lot of raffles and things like that if you can be there in person. Otherwise, take a look at it online. I know what people are going to be talking about. I actually think it's going to be worthwhile. Again, it's free. You don't have to pay for this thing. All right. Did I miss anything? I think I got it all.
Did you say it was free?
The shirts are awesome, by the way, people. The quality,
Yes.
it's not one of those shirts you get in the mail after you order it and you're like, oh my God, I'm not going to wear this thing. Quality is 110% A+ stuff. Hey, you should try it. I'm telling you right now, it's good stuff. I wear it all the time.
Yeah, this
Remington's
is not
wearing
Wish
his
app.
shirt right now as underwear. That's how soft it is.
There you go.
Right? All right. Thanks again, guys. And we will see you next Tuesday.